I've heard several concerns over and over again that Europeans have about data privacy in the United States. And the three principal concerns I hear are concerns about redress, whether the United States provides adequate redress, data collection, what are the limits on collection of data in the United States, and then the issue of independent oversight, whether there is sufficient independent oversight of data protection in the United States. There are several avenues to judicial redress in the United States. The first one would be the Freedom of Information Act, which allows anyone, regardless of citizenship, to go to court to seek access to and obtain access to data that the U.S. government has about them. There's a simple form you fill out online. 15 days later, the agency would tell you whether they've got data about you and would begin the process of collecting that data to distribute to you. If you're not satisfied, ultimately, with the agency's response, you can go to court to enforce that right. There's another statute that's particularly relevant in the context of law enforcement data that's held in databases, and that's the Criminal Fraud and Abuse Act. And that provides judicial redress to anyone, regardless of citizenship. This act prohibits government employees from accessing government databases and obtaining personal information about people and using it for improper purposes. It also prohibits government employees from going beyond their authorized access. So for instance, if you were authorized as a government employee to use information for one purpose, but you went beyond your authorized access and used it for another purpose, that would be an improper purpose, and you could be not only would you be subject to a civil suit by an individual regardless of citizenship, but you might be criminally prosecuted for doing that. And in fact, the U.S. Brings criminal prosecutions against government employees who wrongfully access government databases and access personal information. Then there's several other sector-specific statutes that provide judicial redress to anyone regardless of citizenship. When the government, for instance, improperly accesses financial records, broadly defined to cover a wide range of financial institutions. When the government wrongfully accesses your credit report information, your driver's license information, your electronic communications, whether that's email or phone records, for instance, there is judicial redress available for all citizens, not just U.S. citizens, but all persons under those statutes. One of the other things I hear a lot about is concern that U.S. law enforcement does not need a legitimate basis or a legal basis to collect information, that it could go on what we would call a fishing expedition to scoop up large amounts of data without any kind of suspicion of wrongdoing. And that's just not so. In the United States, we've got very strict rules and laws about collection of data. There must be a legitimate legal basis before the government can collect data, and it's provided by statute or by federal regulation. At the very least, the data must be relevant to an investigation. And then for more sensitive types of data, law enforcement must actually show something more than relevance. Sometimes law enforcement must demonstrate through actual specific facts that the information sought is needed for an investigation. And this type of request would require a court order from a judge. And then the most sensitive data requires a warrant based on showing of probable cause that the evidence is likely to, the information is likely to yield evidence of a crime. All of these types of requests from law enforcement for data can be challenged by the recipient in court. So an individual who receives a request from law enforcement for data can go to court to challenge the legitimacy of that request on the basis that it requests information that's not relevant, that it's overbroad, that it's not tailored enough. In fact, one of our Fourth Amendment to our Constitution has a particularity requirement which requires all warrants for information to describe with particularity the information to be seized. And that was put into the Fourth Amendment of our Constitution expressly to prohibit the kind of wide-ranging fishing expeditions that the American people wouldn't tolerate. One of the other questions that comes up a lot is the question of oversight, independent oversight, and whether oversight in the United States is sufficiently independent. And again, I go back to the fact that the U.S. has a different governmental structure than European countries do. And so the independent institutions in the U.S. system might look different than they do in Europe. And that is just a function of our Constitution and the way our Constitution set up our three branches of government. I would note that the Protocol 181 to the Council of Europe Convention, when it describes the kind of independent oversight bodies that European countries, that member states must have, it gives great leeway to member states to develop and put in place the kind of independent body that makes sense given their governmental institutions. And so just as the Council of Europe Convention gives that leeway to European countries, I think then Europeans would be able, if they think about that, to understand that in our country we have different types of independent oversight. We've got inspectors general who have independence from the agencies in which they're embedded, and they're vested with subpoena power. They can bring investigations, they can refer criminal prosecutions, and they can and disciplinary action as well against individuals in that same agency, and they're in fact required to do that. That is their, not just their authority, but that's their mandate from Congress. We have privacy officers in government agencies who are required by law to ensure that there are adequate procedures in place to provide redress, for instance. Provide redress to persons who are concerned that their privacy has not been adequately protected. And then finally, there is a new statute in the United States to set up what is called a Privacy and Civil Liberties Oversight Board. And this is a board that consisting of members who are, while appointed by the President and will be appointed by President Obama, must be confirmed by the Senate and serve out 6-year terms. So their terms are independent of the President's, are not coterminous with the President's term. And they exercise a great deal of independence. It's designed to be an independent agency, again with subpoena power. It's a fairly new statute, and they will have oversight authority, independent oversight authority over all privacy and civil liberties issues that arise throughout the federal government.